Assalamualaikum and welcome to our TV legal discussion today's show. So my name is Adam Mirza and I am a criminal law lecturer from University Kebangsaan Malaysia. For this session, I have two guests with me, Mr. Takib Zikri, who is a public prosecutor, and Mr. Hazim Asri, who is a respected criminal lawyer. So today, we will be discussing an important and sensitive issue in Malaysian criminal law, which is not widely covered, namely the offence of infanticide under section 309A and 309B of the Penal Code. So our focus is one major question. Does Malaysian law properly balance two competing concerns, which is the protection of infant life and the recognition of postpartum mental disturbance suffered by mothers after childbirth? So today's discussion will argue that infanticide should not be abolished or discriminalized. Instead, Malaysian law should reform to make the offence clearer, fairer, more consistent and more medically informed. So, to begin, let us understanding the meaning and nature of infanticide from the perspective of Mr. Taki Zikri, Deputy Public Prosecutor. What is the perspective of the prosecution and what is infanticide? Thank you.
Thank you, Adam. For this session, my name is Takib Zikri and I will be the panelist in the point of view of public prosecutor. So, in simple terms, infanticide refers to a situation where a mother causes the death of a newly born child while her mother's state is disturbed due to the effect of the childbirth. However, it is important to understand that infanticide is still a serious criminal offence. The death of a child is involved and the law cannot simply ignore the fact. From the prosecution perspective, the law must protect infant life because a newborn child is extremely vulnerable and dependent. And I agree that infant life must be protected. However, infanticide is different from ordinary murder because the law recognizes that childbirth may seriously affect a mother's mental condition. A mother may suffer from postpartum depression, postpartum psychosis, trauma, and other childbirth-related mental disturbance. So, infanticide sits between criminal liability and medical compassion. The mother is still legally responsible, but her culpability is reduced because her mental balance may have been affected. And that is an important point. Infanticide is not a complete excuse. It is a mitigated homicide offence. In other words, the court still punishes the act, but it also takes into account the mother's vulnerable mental conditions.
Alright, so now let us move to the legal framework. In section 309A of the Penal Code provides the legal definition of infanticide in Malaysia. So what are the main elements of this offence? So there are several elements that must be proven. Basically, the first, the accused must be a woman and the biological mother of the child. This means that father, adoptive parents, relative or caregivers cannot rely on section 309A even if they are emotionally distressed. Second, the victim must be the mother's newly born child. However, Malaysian law does not define the exact age limit for the phrase newly born child. This creates uncertainty and confusion because it is unclear how long after birth a child can still be considered as a newly born. So the third, the death must be caused by a willful act or omission. This is important because the law covers both positive acts and failures to act. For example, I give you, it may include a direct act causing death or an omission, such as failing to feed the child, failing to protect the child, or failing to seek medical care. And fourth, the mother must not have fully recovered from childbirth. And because of that, the balance of her mind must have been disturbed. So basically, in conclusion, section 309A requires a clear connection between childbirth and the disturbance of the mother's mind. It is not enough to say that the mother was emotional or under pressure. Hence, that's why the law requires the disturbance to be linked to the effects of childbirth.
So thank you, Mr. Hazim Asri. So now, let's discuss the punishment for infanticide. So, what does section 309B provide? Section 309B of the Penal Code provides that the punishment for infanticide a person convicted of infanticide may be sentenced to imprisonment for a term of up to 20 years and may also be liable to a fine. So the important point is that unlike murder, the punishment for infanticide is not fixed. The court has discretion to decide the appropriate sentence based on the facts of the case. So the decision is very important. It allows the judge to consider that mother's mental health, personal background, age, trauma, social support, and prospect of rehabilitation. So from the defense perspective, this flexibility is very necessary because not every case is the same for infanticide cases. Some mothers, they may be young, they may also may be isolated, traumatized, or suffering from serious postpartum psychiatric condition. So therefore, the punishment of infanticide under Section 309B, it reflects the special purpose of infanticide law. The law still maintains accountability for the death of a child, but it avoids excessive punishment where the mother's mental condition significantly reduces her responsibility.
Now, let us consider the broader purpose of infanticide law. Why does the offence exist? Historically, women who kill their infants were often charged with murder and faced extremely harsh punishment, even when they were mentally unstable after childbirth. This creates injustice because the law did not properly recognize the medical and psychological effect of the childbirth. The Section 309A provides a more human legal responses. It recognizes the postpartum psychiatric disorder can impair judgment, emotional control, and also understanding. But at the same time, the law must not become too lenient. The purpose is not to excuse the killing of an infant. The purpose is to ensure that the punishment is proportionate to the mother's actual moral blameworthiness. And infanticide law has three main objectives. The first is that to protect infant life, and the second to recognize the medical reality of the postpartum mental illness, and the third to impose punishment that is fair and proportionate to the mother mental condition at the time of the offense.
Right, so thank you. Now we'll continue the presentation and I will explain to you guys why we need to understand infanticide properly, especially regarding the postpartum mental disorders. Yes, basically, postpartum mental condition exists on different levels of seriousness. The first that we need to understand is postpartum blues. This is usually mild and temporary. It may involve sadness, anxiety, emotional instability, and crying after childbirth. The second is that postpartum depression. This is more serious and it may involve deep sadness, hopelessness, anxiety, exhaustion, and difficulty bonding with the child. The third one is postpartum psychosis, and it involves hallucination, delusions, confusion, and a serious break from reality. In extreme cases, this condition can contribute to dangerous conduct involving the infant. So, another side, the medical evidence become very important here because why? The court cannot simply assume that every mother who kills a child is suffering from postpartum mental illness. There must be a proper evidence to show that her mental disturbance was connected to childbirth. That is a key point that we need to understand in the Section 309A that recognizes that a mother suffering from such conditions may not have the same criminal responsibility as someone who kills with full intention and awareness. However, the law still requires proof that the mental disturbance was connected to the childbirth.
Thank you, Mr. Hazim, for the explanation. Now, we'll be moving on to the needs of distinguishing infanticide from other related offences under the Penal Code. So, in the Penal Code, there are other offences that relate to infanticide, but it's not infanticide, especially in Section 312 to 316 of the Penal Code. So, to begin with, Section 312 and 313, it concerns about miscarriage. So, including miscarriage without the woman's consent. Second, Section 314, it deals with the death caused during an attempted miscarriage. And third, Section 315, it concerns acts intended to prevent a child from being born alive. And lastly, Section 316, it deals with causing the death of a quick unborn child. So, these provisions in the Penal Code are related to pregnancy and unborn life, but they are not the same as infanticide. So, the key distinction in this section provided and in the Penal Code is timing. So, Section 312 to 316 generally deals with acts before birth. However, infanticide under Section 309A, it only applies when the child has already been born. And another important difference is that infanticide, it requires the offender to be the biological mother of the child. So thus, the offence of infanticide requires proof of childbirth-related disturbance of mind. So, in conclusion, not every death involving a baby or pregnancy is infanticide. The legal classification, it depends on timing, identity of the offender, the status of the child, and the mother's mental condition.
Thank you, Adam Mirza. And let us now move to the Malaysian case law. And the case that I handle myself is a public prosecutor against Zami here. So, in this case, the accused threw her 2-month-old baby out of a moving vehicle, and the court accepted medical evidence that she suffered from a puerperal psychosis. Because of that, she was convicted under Section 309A for infanticide rather than murder. This case shows that the importance of psychiatric evidence in reducing liability from murder to infanticides. And this case is also important because it shows that the prosecution in this case and the court must carefully consider the accused's mental condition if there is a medical evidence showing that childbirth-related disturbance of mind, then a murder charge may not be appropriate. However, the seriousness of the act remains. The law does not deny that a child died. It only adjusts the level of the criminal responsibility. Next case is a public prosecutor against Norazwi Muhammad Noor. And in this case, the accused dropped her newborn child from an apartment. However, the court found that her mental condition amounted to the legal insanity under Section 84 of the Penal Code. This means her condition went beyond the lesser disturbance required for infanticide. That case is very important because it shows that the difference between murder, infanticide, and insanity. Infanticide involves a disturbed balance of mind due to the childbirth, but insanity under Section 84 requires a more serious level of mental incapacity. Therefore, the Malaysian court must carefully distinguish between these categories. The correct charge depends on the mother's mental condition at the time of the offences.
Alright, so thank you Daki. So another segment, we will critically evaluate about the Malaysian law. So what are the main witness in the Section 309A of the Penal Code? So the first major of witness is that Section 309A does not define newly born child. And of course, this situation creates uncertainty because courts must decide on a case-by-case basis whether the child still falls within the offence. Without a clear age limit, different courts may reach different conclusions. The second witness is the lack of a clear legal or medical definition for disturbance of mind. The Penal Code does not explain whether this requires a diagnosed psychiatric illness or whether general emotional instability is enough. And this situation creates difficulty for prosecutors, defense lawyers, doctors and judges because of this confusion. And the third witness is the absence of mandatory psychiatric assessment. Without proper medical evaluation, some others may be wrongly charged with murder, and at the same time, some accused persons may rely on infanticide without sufficient medical evidence. The fourth witness is inconsistent charging and sentencing. Similar cases may be treated differently depending on prosecutorial discretion, available medical evidence, and judicial interpretation. This is why reform is necessary. The law must be clearer so that justice does not depend too heavily on uncertainty. Therefore, Malaysian courts must carefully distinguish between these categories. The correct charge depends on the mother's mental condition at the time of the offence.
So lastly, to complete our discussion, let us compare Malaysia with other country jurisdiction. So what can we learn from these countries? So first, I will provide the jurisdiction of United Kingdom. So in the UK, they provide a clearer model because its Infanticide Act applies to children under 12 months old. So this it gives a legal certainty because the age limit is clearly stated. However, in certain cases, it may also be too rigid in cases where postpartum illness that continues beyond 1 year. Second, in Canada, it adopts a more flexible approach. So in the famous case of infanticides, in the case of R against Borowicz, the court held that disturbed mind, the phrase disturbed mind does not require full insanity or a major psychiatric diagnosis. So this allows the law to recognize a wider range of postpartum mental disturbances. And third, in Australia also has different approaches between their interstates. Victoria is more progressive because it extends the age limit to 24 months, recognizing that postpartum disorders may continue beyond the first year. So lastly, in the country of India, by contrast, India has no specific infanticide offence. So mothers are generally prosecuted under ordinary homicide law. So this makes it harder for postpartum mental illness to be properly recognised within the criminal justice system. So based on this comparison with other country jurisdiction of infanticide law, Malaysia, we believe that Malaysia should retain infanticide as a distinct offence, but there need to be some reforms. So there are four main recommendations of reform that Mr. Taki Zikri as a public prosecutor and Mr. Azim Asri as a criminal lawyer will give their recommendation.
Thank you, Mr. Adam Mirza. There are four main recommendations that coming from me, that is to amend or to reform the Infanticide Act. The firstly, Malaysia should define what is a newly born child, is to provide a legal certainty of the Infanticide Act. Second, Malaysia should require mandatory forensic psychiatric assessment in suspected infanticide case. Third, prosecution guidelines should be introduced for infant death cases so that the decision to change to charge for murder, infanticide or other offences are more consistent from time to time. And lastly, Malaysia should develop a sentencing principle that focus more on the treatment, rehabilitation and mental health supports.
Alright, so now we look at from a defense perspective. Okay, so these reforms will protect vulnerable mothers from being treated unfairly as ordinary mothers when their mental condition was affected by the childbirth.
So, to end our legal discussion TV show today, we would like to conclude that Malaysia should not abolish or decriminalize infanticides. This offence remains important because it balances accountability with compassion. However, we conclude that the law must be improved through clearer definition of a newly born child. There must be psychiatric assessment provided and prosecutor guideline with it, and also the rehabilitative sentencing. So this would make Malaysia infanticide law clearer, fairer and more consistent for the future cases of infanticides. So we would like to say thank you for watching our discussion on the jurisprudential dilemma of infanticide in Malaysian criminal law. Thank you. Bye bye. Dah record.